But we were good at talking, that's why we make good lawyers, but we are not good people on making roads. So there's a good advantage in that. Now, because of the idiosyncrasy, we were able to make sure the generic industry could survive. Now, once that happened, the MNCs did not realize the import of it. We realized it. We also thought that there is a defeat. But the first case which came up for interpretation of 3D was the Novartis case on the drug Glivec. What is Glivec? It's an anti-cancer drug. It is, the original molecule is imatinib. The press release is out, by the way, so you can take that. And I'm just explaining it to you so that when you read the press release it will be simpler. So, now, imatinib was patented in the US and Canada, but it couldn't be patented here because that was pre-1995. By the time the patenting regime came here, they had discovered imatinib mesylate, which is a salt form, and a crystalline form of imatinib mesylate, which is the beta crystalline form. So they sought to patent the beta crystalline form, saying that this one is more efficacious than imatinib. So they applied for a patent before the patent controller, and in order to show that it is patentable, there are two things which are very important internationally which have to be satisfied. I'll just explain to you simply because I want you to write your own piece. You know, you'll be patent lawyers after this, like the judges have become. So first thing is it has to be new, or it's called novel. Novel is a simple concept. Has it been shown in any single document with all its limitations, but not in more than one, only in a single document? If it is shown, then it is not novel. Very simple. Suppose beta crystalline form of imatinib, has it been disclosed in any document, beta crystalline form? No. The answer is no. Or has it been produced? It's called practiced. In patent law it's called, has it been practiced? So if it is produced before the date you make the application, which is known as the priority date, then it is not novel. Very simple. Anybody can do it. But the second one is more complicated. The second one is, okay, it's novel. You made a beta crystalline from imatinib mesylate or imatinib. Could a person who is skilled in chemistry would have thought of the beta crystalline form and made it? If that person could have thought of it, it's obvious. It is not inventive. Okay, that is the meaning of inventive. It's easy to explain it, but when the case is gone, it becomes quite complicated. But that's the meaning of it. Inventive step means a person skilled in the art would have thought of it and be able to make it. Okay, and in our law, then the 3D comes in. There's another thing which is not important. Is it industrially applicable? If you have a great idea, you can't use it industrially. It is not patentable anywhere in the world, but we are not concerned with that. We are only concerned with, is it novel, is it inventive, and is 3D in India applicable? So at the patent of 3D, is it significantly more efficacious, the new form than the known substance? That is 3D. We know only the 3D now. We don't talk of the long-winded thing. So the patent controller said, it is not novel, it is not inventive, and 3D doesn't allow it to be patented because it is a new form. Crystalline form of imatinib mesylate is a new form. They argued that even the mesylate is new. Okay? Then they had challenged it in the Madras High Court, saying this 3D is not compliant with TRIPS and it's not constitutional. Madras High Court said, I won't use bad language, but they told them they are rejecting it. Though they deserved all the bad language that you can have. Because these are mercenaries. I can tell you that I've also said this in open public speeches, and I was issued a notice by Daniel Vasela saying that I'm hired by generic companies, so I issued a legal notice to them.